Hotline là chị rồi đúng không? Máy của chị đang bị đơ và chị đang dừng.
Good afternoon. Good afternoon. Good afternoon. Welcome to our final webinar in the 2021 VIAC arbitration series. So I'm so proud to inform you all that over the last month, we have together explored on a number of dimensions of arbitration and also international arbitration in Vietnam, which are arbitrator appointment, pre-arbitration procedures, seat of arbitration, cost in arbitration, and also corporate and M&A arbitration and interest in arbitration. So in this 7th webinar, as a sum up, we would like to bring you audience back to the basics, to where all of this of those discussion might start with is drafting an arbitration agreement. From time to time, someone tries to define what a perfect arbitration clause would look like, and efforts to do so usually founded on one of the strengths of arbitration, which is its adaptability to the particular circumstances of the parties and the dispute. Therefore, while it is difficult to generalize what would make a perfect clause, it is not nearly as difficult to identify some of the features that make for the bad one. In fact, many parties fail to realize that the wording of an arbitration agreement is important for arbitration to function smoothly. In practice, however, one may observe recurrent scenarios where arbitration clauses contain defective wordings and thus are subject to unnecessary incidents and procedural debates. Such clauses are called pathological clauses. And therefore, our webinar today is focused on avoiding pathological arbitration agreements, do and don't in drafting process, with the purpose of revisiting the basic notes in drafting process of an arbitration clause and open up discussion with our experts who are experienced counsel, lawyers, and arbitrators to exchange practical knowledge to find ways to tailor an arbitration clause that meets the parties' particular requirements in a specific transaction and fit with possible disputes that may reasonably be anticipated, and how a defective arbitration clause being dealt with in practice in different jurisdictions of Vietnam and Singapore. Our keynote speaker today, I would like to introduce Mr. Nguyen Trung Nam, Mr. Tony Nguyen, a VIAC listed arbitrator who is always considered a little too young in age to all of his achievements. Tony is among few Vietnamese fellows of the well-known Chartered Institute of Arbitrators in London, UK, and experience in international arbitration in Vietnam and other jurisdictions. Together with Tony, today are his panelists. First, Mr. Yujin Tay, the partner of Mayer & Brown in Singapore, the head of the international arbitration. Mr. Yujin Tay is based in Singapore and also a VIAC-listed arbitrator who have seated in complex arbitration cases in Vietnam. The second is Mr. Doan Nhat Minh, Senior Associate of the Litigation and Arbitration Team at VIAC Hồng Đức, one of the biggest name in the legal law firms of Vietnam, who could be a representative of the young generation of Vietnamese lawyers who are professionally practicing in arbitration in Vietnam. Last but not least is our counsel, Ms. Dao Nhu Ngoc Linh, the newest to join our counsel team at VIAC, who is well trained on international dispute resolution in Queen Mary University of London, one of the top universities in the world on ADR. So without further delay, I'd like to invite Mr. Nguyen Trung Nam, who will give us the keynote speech on the topic, and then he will be the moderator of the panel discussion. So Mr. Nam, please.
Thank you, the organizers. First of all, I must thank VIAC and Ms. Han in particular for arranging for all these very interesting topics today. And also, very importantly, we have old friends. We met again, Mr. Yujin Tay and also Mr. Minh, also very frequent speakers that I myself invited him to join some of the events that we organized. The agenda today, I will try to give all the audience a very brief, basic understanding of the core elements of the arbitration agreement. What is the most important and why these are important, and also some few cases for you to consider in relation to the topic that we have today is a pathological arbitration clause. And then I will invite Mr. Yujin Tay, Mr. Minh, and Ms. Linh, our counsel from VIAC, to share their respective experience from Singapore law perspective, from Vietnamese law perspective, and from the biggest institute, arbitration institute in Vietnam, VIAC experience. I will share the slides so we can go quick. I hope you can see the screen now. I will go quickly on three main contents. Firstly is the key requirements for a valid arbitration agreement on AA. Secondly is the core elements of international arbitration agreements. And thirdly, pathological AA solutions and how to prevent these to happen with your contracts. Sorry, I have to say this should be the first of everything. When we talk about arbitration agreement, it is the source for an arbitration proceeding to take place. In other words, it's the beginning of the whole arbitration world that we are talking about. So it is very important for an arbitration agreement to stand when you go to an institution, you want to file a notice of arbitration. The first thing that people will ask you is an arbitration agreement, right? When you have an award, you bring the award to a court, or you bring the award to any country that you have knowledge that the assets of the loser is having, then you will have to bring the arbitration agreement to them in the first place. So it is so important to have a valid arbitration agreement to commence all the arbitration proceeding that we want to select as an alternative to litigation. And in terms of requirements, we have two limbs in the requirements. First is the formal requirements. So the formality, how are you going to sign it? Who will sign it? And what is the key requirements for things to be included, right? And secondly is the substantive requirements. In terms of the formality, we need the agreement in writing to be able to utilize the New York Convention 1958, because the New York Convention provide that agreement in writing include an agreement clause in the contract on arbitration agreement signed by the parties or contained in an exchange of letters or telegrams. This is the limit that the New York Convention will accept as an agreement in writing. And if an agreement is not in writing, you are unable to bring the arbitration agreement to the award as a result of the arbitration proceeding to get it enforced and accepted in another jurisdiction. So it is very important to keep that in mind. We have what we call the model law. And the model law, the latest version is 2006. It has two options of Article 7, which require in the first option that the agreement must be in writing, but it expanded the concept of writing, which recognize a record of contents of the agreement in any form. So it tried to accommodate the recent development in the way that people can negotiate and conclude their arbitration agreement or all their agreements together, including text message, WhatsApp, whatever you can put in the contents of the agreement in any form. So it's expanded a little bit compared to the original New York Convention, which is half a century ago. Option 2 is more liberal. It gives the most freedom to the parties' agreement. So you can pick up the phone and you call, you have an agreement. That agreement includes an arbitration agreement. If you mention that in your discussion, it is qualified as a concluded agreement under the Model Law 2006, Option 2. So that is a formal requirement. I'm pretty sure that later on our distinguished speakers will talk more about this in the context of Singapore law and Vietnamese law. I know that Singapore is a model law country, but Vietnam is not a model law country. So there are a few things that we want to talk about, the formality requirements. And just a small hint for you who are not familiar with these. In Vietnam, I think about 1/3 of the cases where the arbitration agreement is challenged, it is related to the formalities. So all the time we see again and again, the parties, the losers, try to convince the court that the formal requirements have not been met, and therefore the arbitration agreement is not established. So there's no arbitration agreement, there's no arbitration. Regarding the substantive requirements, we have a few things that we have to take into account. The first thing is the capacity of the parties to the arbitration agreement. And this will need to be considered in the context of the law governing the entities that are entering into the arbitration agreement. For example, a Turkish company signed a contract with a Vietnamese company for a sales or trading contract. So which law will govern the capacity of the Turkish party in relation to whether or not the Turkish party has the legal capacity to enter into that arbitration agreement? So that question needs to be considered or addressed in using the law governing the Turkish company, which is the country where the Turkish company resides or registered. And that has been clarified quite a few years ago in, I think, in the resolution number 1 in 2014. Before that time, a lot of courts in Vietnam believe that Vietnamese law will apply to consider whether or not the party has the capacity to enter into the contract. So in practice, there are more than you can think of that can cause the arbitration agreement to be invalid because the party has no capacity. And then the agreement must be valid under its governing law. So there are a few confusion here that people may have. The law governing the arbitration agreement might be different from the law governing the substantive contract because of the separability principle. So the arbitration agreement is separate from the substantive contract. And the validity of the arbitration agreement is also separate from the validity or the life of the substantive contract. So we have to consider whether under the law governing the arbitration agreement, that arbitration agreement is valid. And as a matter of Vietnamese law, we can look at if the Vietnamese law is a law governing the arbitration agreement, then it's quite simple. If we look at the subjects that can be the disputes that can be settled by arbitration, in a few other countries, there are certain limitations or areas that you are allowed to choose arbitration for your disputes settlement. In Vietnam, such limitation is very minor, it's very narrow, because you have the arbitration, commercial arbitration law, which provides that as long as you have one commercial, one party doing commercial activities, then the dispute can be brought to arbitration. So the arbitrability under Vietnamese law is even larger than some other countries. But it is something that you have to keep in mind. Some of the disputes, for example, employment disputes, will generally speaking cannot be brought to arbitration. Or criminal things, of course, cannot be arbitrable, right? The next question is on the wording of the agreement, whether or not it has the clear intention of the parties to establish an agreement to submit the dispute to arbitration. So you must have something like the parties will bring the dispute to arbitration. So it must be clear, and it cannot be a vague reference to some sort of amicable resolution, things like that. So as to the wording of the contract, the intention must be clear. The agreement, the meeting of mind must be clear. And because arbitration is a creature of contract, it needs the correct wording in the arbitration agreement. And before you can have an efficient arbitration, you must have an effective arbitration agreement. So it is a start for everything. And that is why I said to Ms. Hằng that we should have this in the beginning of the other seminars, because this is really the start of everything. If you draft a very poor arbitration agreement, what is the consequence? You may have parallel proceedings. You may have different arbitrations, litigations happening at the same time. You may have a lot of opportunities for the losers to challenge the tribunal's jurisdiction, or the parties who want to get away from the contract, to avoid obligations, to challenge the tribunal's jurisdiction, and to prolong the process of dispute settlement. And it will affect the chances of the successful enforcement. As I said before, if you have a poor arbitration agreement, you can't bring it to, for example, the formality is not qualified to the standard of the New York Convention. Then you cannot use the New York Convention to bring it to, for example, Vietnam for recognition and enforcement under the New York Convention. And finally, it can bind the parties to more expensive and more lengthy procedure and very ineffective, because in business, time is money, right? If you have a process that is a lot longer than you could expect, then maybe at the end of the dispute resolution process, you find yourself in a very silly situation. You talk to yourself, why should I do this? After 5 years, I received like 100,000 and I have spent 5 years, a lot of resources, right? Then I go to the core elements in an international arbitration agreement. I hope that this is providing you with some key concepts and also some considerations when you actually go to draft an arbitration agreement. So these are the things that you will need to consider. I'm not going to go through all of them because I know that VIAC has got quite a few very interesting and very insightful seminars, webinars on these issues. So I will go through as a matter of systematic approach for you to learn how you will assess an international arbitration agreement when you draft such a very small arbitration clause. There are more things than you imagine. Firstly, you have to decide whether you choose institutional or ad hoc arbitration. Institutional arbitration is the most popular approach that people should think about, because the institutional arbitration will give you the arbitration rules. That is very convenient for you to use. And not only the rules, they have a team like VIAC, for example. They have a secretary, they have assistants. They will assist the parties with all the logistic needs, all the explanations in terms of payment of fees and so on and so forth, and the coordination with the arbitrators. So it is very convenient. Of course, it's more costly than ad hoc arbitration, but if the parties are not very very professional in dispute settlement, they should use institutional rather than ad hoc, because ad hoc you will need to build up your own proceedings. You need to agree on the proceedings in order to start, in order to commence. The second element in consideration is to choose which institution and which rules, right? You have learned a lot if you go to a lot of webinars and seminars in the world today. I think each day we have about 4 to 5 different webinars talking about the advantages, the trends of the different rules of international arbitration institutes. For example, CIAC. Every week I see 2 or 3 CIAC events. ICC, we have like quite a few events in the last month, and also this month we have a lot. So they will give you information of how they perform. So you have to choose which institution, CIAC or ICC, Hong Kong IAC, AIAC, or maybe a little bit further, LIC, LCIA, or AAA even in the US, ICDR. So all these kind of things, you need to collect information about them. Sometimes you have to, you are pushed to learn about them. I have a client who get a request from their partner to be forced to choose arbitration in the US, in New York, the seat in New York. And they do not understand how these proceedings will take place in that institution. So you will have to learn and to pick up those that you understand the risk and understand the way that they are doing. The third element is the scope of arbitration agreement. For this, I'm going to go to more. I forgot to mention, when you choose the rules and when you choose the institutions, make sure that you quote the correct name. Because later on you will see if you put the wrong name, then the whole purpose of choosing the organization, the institution will be lost. And that will be that will put you in a very difficult position. Because obviously the parties choose that particular institution and they were happy with that procedures, the rules by that organization. But later on when the dispute arises, if you want to initiate an arbitration and you want to file a claim to a notice of arbitration in that institution, maybe the other party will just try to block you out because you quoted the wrong name. Usually the arbitration institutions, they have their standard arbitration clause that you can copy to your contract. So the arbitration clause, if you already choose a rule, you already choose an institution like VIAC or CIAC or ICC, the first thing you should do is to go to their website to see their standard clause. You should start from their model clause as the clause that you are looking at here. Any dispute arising out or in relation with this contract shall be resolved by arbitration at the VIAC. And they also have some options that you can choose, and then you can take choices. The place of arbitration could be a city or country, and the governing law of the contract should be some substantive law and the language, and so on and so forth. The problem with the scope of arbitration agreement is that sometimes different parties, including the courts and the arbitrators themselves, they have different views on how broad is the scope that you can bring to arbitration. So when you say that we bring these disputes to arbitration, what happens if in the dispute you have a head of claim with contractual breach, and you have another head of claim with a non-contractual breach, which is, for example, the contractor has a default that is not given in the contract, but it is a constitutional provision. So it's mandatory law that requires the contractor to perform some particular activities, and it failed to do that. So the question will be whether the arbitration clause is broad enough, the scope of the arbitration is broad enough to cover such non-contractual disputes or non-contractual breach, alleged breach. So some of the courts have knowingly stated that the wording arising under was more restrictive than arising out of. So if you say something arising out of something else, the language will be able to cover a little bit more. And that may be covering the non-contractual claims. So it will give you more flexibility to plead, to establish your claim. Because in the contract, you have contractual claim, non-contractual claim, and we have had this dispute. I'm pretty sure that Mr. Minh later can share with you some evidence in Vietnamese court that the court was requested to decide whether or not this problem or this part of the dispute is arbitral or not. And that all relates to how you draft your arbitration agreement in the first place. What we recommend, if you want to have more flexibility and more broader scope of arbitration in your arbitration clause, is a little bit modified version of the VIAC model clause. As you can see on the screen, any disputes, any controversy or claim arising in any way out of or in relation with this contract, including without limitation to any contractual, pre-contractual. This includes, for example, letter of intent or some pre-agreement between the parties, or non-contractual rights, obligations, and liabilities. And second, any issues as to the existence, validity, or termination of this contract shall be resolved by arbitration at VIAC. So you will see this is a little bit expanded version. And if you bring this to a tribunal in the VIAC, if you bring that to me, you will find a general acceptance by the arbitrators that it will cover not only the contractual claims, but even some pre-contract claims or non-contractual claims, some claims in tort. That is the way that you will expand the scope of arbitration to ensure that you can use arbitration for a variety of the disputes that will arise from your contract. I'm not going to talk about the seat of arbitration. I can't talk more about the importance of how of the selection of the seat by the parties. Selecting the seat will give you actually the whole environment of your arbitration proceeding. But you already have another VIAC webinar on the seat of arbitration, so I'm not going to go into that much detail. Instead, I'm going to address a little bit the law governing the arbitration agreement. As I said before, the law governing the arbitration will be different, may be different from the law governing the substantive law. Most of the time, it is considered relevant to be the law of the seat instead of the law of the substantive contract. Let's imagine we have a contract between, again, a Turkish party and a Vietnamese party. The parties compromise and use Vietnamese law to govern the substantive contract, but it says nothing about the law governing the arbitration agreement. And I think most of the sales contract will not give you a clear provision on the law governing the arbitration agreement. So when the case was brought to arbitration, what happened is that, of course, the Vietnamese party will try to convince the tribunal that Vietnamese law, which is the law governing the substantive contract, should be the law governing the arbitration agreement. But the other side, the other side try to convince the tribunal that the law of the seat is more relevant, because this is the arbitration clause. This is all about how the arbitration should work. So the arbitration agreement should be governed by the, let's say, Singapore law, if the arbitration, the seat of arbitration is in Singapore. So the tribunal will have to decide which law to apply. And as a general accepted principle, the tribunal will apply the closest test, the closest connection test. So which law is the closest connection to the dispute? will be the law governing the arbitration agreement. And we have a few cases here for your reference. I will pass on, but keep in mind, it will be a floating citation. If you go to different tribunal, maybe they will decide in different ways on the law governing arbitration agreement. And the law governing the arbitration agreement will help you determine whether or not the arbitration agreement is valid or not valid under that law. Okay. For example, if it is a dispute on real estate, maybe in a country like, I don't know, Philippines, it is not arbitrable. But if it is Vietnam, it is arbitrable. So you can go to, you can choose arbitration, and you have a valid arbitration agreement if you choose Vietnamese law as a law governing the arbitration agreement. I will pass this because the appointment of arbitrators, we have another very interesting, again, a very interesting VIAC webinar on this. I just want to clarify that it is very unusual that the parties negotiate these details of the selection of arbitrators. Most of the time, they will apply only the number of arbitrators, 1 or 3, and not the quality of the arbitrators. So I'm going to pass this, and also the qualifications of the arbitrators. On the substantive law, it is important. It is not part of the arbitration clause. Normally, it's a part of the governing law, the law governing the contract. So it should not be an issue. Now I want to go a little bit to the a specific type of arbitration agreement, which is called the unilateral arbitration agreement. So there are 2 types. The first type is the clause provides that the arbitration is available for both parties, but litigation is only available to one party, usually in the situation with the lenders in a financing agreement. And the second type is litigation available to both parties, but only one party is allowed to bring the case to arbitration. So this is an asymmetric arbitration agreement situation. And in some jurisdictions, it is not allowed. For example, you see in Russia, in France, a few cases already refused to enforce such type of agreement. But in other jurisdictions, for example, English law, you see cases where the court accepts that approach. And that is why a lot of cases, the parties, when they negotiate the contract, the lenders always request the other side, the borrower, to accept the arbitration clause and the whole governing law of the contract to be English law, because English law allow the enforcement of that agreement. The next specific type is the multi-tiered arbitration agreement. The multi-tiered arbitration agreement, there's another webinar of the VIAC covering this. So I'm not going to go into that details, but I want to focus on one point in relation to multi-tiered arbitration agreement. This is something that has to happen as a pre-action before you can bring the case to arbitration. Sorry. Yeah. If you talk about another type of activities, usually it's negotiation or amicable settlement before you can bring the case to arbitration. So the question that I would like to bring to you now, and we can discuss later, is that if I have an arbitration clause which provides that, sorry, I think I made it wrong here. It should be met up, not up met. I put it wrong. You have to, if the arbitration clause provide that you have to, if you have a dispute with the other side, you have to bring the case to mediation first, and you go to VMC, Vietnam Mediation Center, where I'm the deputy director. And that's why I use this example, and try to solve the problem using the mediation service with VMC. And if that does not succeed within 30 days, then you are allowed to proceed with the arbitration. Do you think that this clause is enforceable under Vietnamese law? Maybe Yujin Tay can share with us whether or not it's a valid clause under English law, Singapore law. The last thing on these core elements of the arbitration agreements is my tip for anyone who are having disputes, or maybe having potential disputes in this COVID-19 era. What you have to be careful is that Vietnamese law is currently not supporting the virtual hearing or conducting the arbitration proceeding, because in the law, it does not allow you to proceed with virtual hearing unless both parties agree. So that is a very strange interpretation of the law. But currently, the situation is that under various rules, including the VIAC rules, you need the other side to agree for a virtual hearing. And that will effectively eliminate all the opportunity for you to have a good arbitration proceeding in Vietnam if you can't choose your, for example, foreign arbitrator, all right? So you should put in your arbitration clause an additional wording like this. Upon request of a party, the tribunal may conduct procedural meetings and any hearings via video conferencing or other virtual means or platforms. This will allow you later, if you have dispute, to unilaterally request the tribunal to proceed with virtual hearing. And that fit in with the COVID-19 situation where you cannot bring your appointed arbitrator or arbitrators to travel to Vietnam to attend physical hearing. So that's a few things on and finally, a few things on pathological arbitration agreements. These are arbitration agreements that have reference to non-existent arbitration institution. I already covered that. And secondly, the arbitration agreement to be optional. So it's not a conclude selection. It's an option, as we mentioned above. And it has a defective mechanism or appointing arbitrators, for appointing arbitrators. For example, it tried to appoint the arbitrators that do not exist in the market, right? And blank clauses. So this is a non-existent arbitral institutions. In international arbitration, a very common mistake is to refer to something like the ICC in Zurich, in Vienna, in Zurich, in Geneva, things like that. And the ICC case number 5103 already recognized the validity of such a clause if it refers to the non-existent arbitral institution. In Vietnam, we also have the same solution. Even if you select a non-existent arbitral institutions, you will have the case that I show you here, the case number 1240. The Vietnamese company requested the court to decide the VIAC tribunal had no jurisdiction over the case. But then the court quoted Article 43.5 of the Law on Commercial Arbitration to conclude that the tribunal has the jurisdiction over the case. So in short, you are allowed to bring, as a claimant, you are allowed to bring the case to VIAC if it is not mentioned in the arbitration agreement. And a blank clause like this, resolution of disputes, arbitration, the place is Paris. So things like this will be troublesome. Another case of pathological arbitration agreement is non-mandatory arbitration clause. In a decision 1222, it provides both for the court and arbitration. So similar to the unilateral arbitration agreement, it has both reference. And the court refused the respondent's request of setting aside the arbitration agreement and hold that the tribunal has the jurisdiction. So Vietnamese law in a certain extent is very advanced and pro-arbitration in that regard. And another decision, the respondent requested the court to set aside the case where the contract provides any dispute can be resolved by negotiation. Sorry, it's another case. And the Article 21 of the contract provide that the contract shall be resolved by negotiation. And then if the parties are unable to reach agreement, then a party may submit to arbitration. So in this case, the parties did not agree to terminate Article 21. So the court held that VIAC accepted the case before it confirmed that both parties had not yet conducted the court proceedings. So if the parties proceed with arbitration first, then the arbitration agreement will kick in, and it will preclude the agreement on the court. So the court decided that the tribunal has a jurisdiction. In the case of the loan agreements, I think because the time has been over for me, I will try to go quickly. The loan agreements, a clause like this, where the English court have the jurisdiction over the case, the lender may choose to submit to dispute to arbitration. And this case has been opined by quite a few law firms in Vietnam to be valid. And a very interesting case, a business cooperative agreement provided that if a dispute cannot be resolved by mediation, the parties will arbitrate, but the seat and location of arbitration will depend upon the party initiating the disputes. If A, the Vietnamese company, initiate, the arbitration will take place in the United States under the ICDR rules. And if B, the US company, initiate the arbitration, then the arbitration will take place in Vietnam under the VIAC rules. So this is a very interesting situation where they try to organize the arbitration clause in a way that is, it looked quite fair. And this is my own client's case. So I told my client, this is a silly idea. You should not do this. You should not do this at all, because we don't know who initiate the case. It could be both parties initiate the case. I initiate the case against you, and then you initiate a counterclaim against me, or maybe an independent arbitration. What will happen is that there will be two arbitrations that will be allowed under this clause, one in ICDR and the other in VIAC. And that will be a huge confusion and waste of time and money for the parties. So in conclusion, we need to make right choices in terms of all the elements that I listed out, the core elements, and don't invent too much. This is not the room for you to elaborate your flexibility, to think of innovative ideas. It should be the time for you to focus on the model clause and try to change as little as you can from that model clause. And once you have selected the seat, try to understand, get to know, get to learn, and ensure that the arbitration agreement operates well under the legislation. And the capacity of the signatory, all the formalities need to be dealt with. And finally, please utilize MedUp. The combo in VIAC and VMC, you have the discounts, because I need to make this advertisement at the end of my speech. And please use the technology that we have developed. For VMC, we have the MedUp that all provide procedures online without any paper. So it's a paperless process. Thank you very much. I will now turn on the floor for Mr. Yujin Tay, who will share with us some experience with Singapore law and also VIAC. Mr. Yujin Tay.
Hi, hello everybody, and thank you, Tony, and thank you to the Secretariat of VIAC for inviting me. Very happy to be here in this way, given that not been able to travel to Vietnam for almost a year and a half, more than a year and a half now. Well, first of all, I think this is a fascinating topic that VIAC and that Tony has chosen. I've had to deal with this issue for many years. This issue of pathological clauses. But one of the things that I usually say with seminars on pathological clauses is to comment that these days, at least in my practice, I come across less and less clauses that are in fact problematic. Not to use the word pathological, I'll touch on that in a moment. And the reason why we encounter less and less of these problematic clauses is because of the types of courses that Tony and many other institutions have conducted. There's so much more understanding of arbitration now. There is a lot of material on the internet. You just Google arbitration clause and you'll find plenty of material. So the quality of arbitration clauses has improved. A lot of the cases that we see, a lot of the judgments and the old cases that we see concern actually these traditional clauses. Some of them may be very dated. I'm very amused by Tony's reference to his selective clause, the one where whoever starts the arbitration first gets the seat of the enemy or the opponent. Actually, it's quite common. It's just a very old clause. These clauses were what I call the East-West clauses that come from, the Cold War era. Maybe most of us are too young to remember it. And you know why they came up with a clause like that? I don't know whether it was an American or a Japanese who thought it was a clever idea. They came up with this clause like this, not because they think it wouldn't work. And actually, I think it actually can work. The reason they came up with the clause was they wanted to discourage arbitration, because they felt that if anybody wanted to go to arbitration and was stuck in the seat of the opponent, then there would be a disadvantage, and therefore they may be discouraged from doing it. And at least from the Japanese and the American perspective, it was successful. The Japanese explained that there's so many disputes and arbitrations they avoided for many, many decades because nobody wanted to go to America for arbitration because they wouldn't understand it. And the Americans didn't want to go to Japan because they also thought they wouldn't understand it. Anyway, with those remarks, let me, I think I will be in the hands of Tony in case you'd like me to touch on anything specific, but I'll make some general remarks and then pass the floor to Mr. Minh for Vietnam, because I do think that the way that this issue is framed for most of the attendees on this webinar is that you have to consider multiple legal systems, multiple laws. That is what makes it complicated for a Vietnamese audience and a Vietnamese practitioner and a Vietnamese party. If I was to be giving the remarks of this seminar in a seminar in Singapore, my remarks are a lot simpler, because all I have to say is that the position in Singapore as a very pro-arbitration, very liberal arbitration jurisdiction, is that many of the things which in Tony's presentation are supposedly defective or problematic, or in the French word pathological, in Singapore are no longer considered pathological. So let's first start with the word pathological. Why do we use it? And honestly, for most of us who are not, if you're not a native English speaker, you are forgiven for wondering what on earth does pathological mean? But it didn't come from English, it came from the French. So in an arbitration context, it's clause pathologique, which was a phrase used in 1974 by, at the time, the Secretary General of the ICC Court of Arbitration. And he was dealing with the fact that in the 1970s, even in the world's most popular seat, arbitration was still a new thing, quite a new thing. So there were a lot of problematic clauses. So he was trying to report to the business community that these are the types of clauses that are a problem. And if they are a problem, then you may not be able to refer your case to arbitration. But the idea of what was pathological or a problem in 1974 compared to what is a problem today in 2021 is very different. So today, I think it is a bit misleading to think about whether something is pathological or not, because it doesn't get you very far. The question is pathological by whose standards, and when are you trying to decide this? And unfortunately, there is no easy answer if you're based in Vietnam, because obviously a lot of the cases you will deal with either will involve a question of enforcement of the award in Vietnam, which means Vietnam law matters from an enforcement perspective. Even if you're involved in an arbitration that may be seated overseas, in Hong Kong or in Singapore or in London, where all the jurisdictions are quite pro-arbitration. But since I'm invited to deal with Singapore, let me just explain the Singapore situation and then I'll pass to Mr. Ming. The Singapore situation now is the opposite of what I would call the Vietnamese situation, which is more conservative. The Singapore situation, we don't apply a test of whether something is pathological. We inherited, or in our applicable arbitration law, so yours is the arbitration ordinance, ours is called the International Arbitration Act. And in our International Arbitration Act, the test that the Singapore courts apply to decide whether a case can go to arbitration or not is a test of whether the arbitration agreement is null and void, inoperative, or incapable of being performed. So the test is to see whether the arbitration agreement is null and void, whether the arbitration agreement is inoperative, meaning it's defective in some way, or whether the arbitration agreement is incapable of being performed. And what makes the what do we mean when you often hear people say that the Singapore courts are pro-arbitration? Pro-arbitration reflects the mentality or the approach or the philosophy of the court in deciding the question of whether a problematic clause is in fact capable of being performed, can in effect be put into, can be given effect. And let me give you a few examples very quickly for some of the types of cases that Tony mentioned. So in the old days, and you'll find a lot of textbooks that talk about this, they'll say, of course, your arbitration clause, you should draft it with mandatory language, which means it should say, shall arbitrate, the party shall arbitrate. But there are many, many clauses drafted even today by transactional lawyers where they say any party may refer this dispute to arbitration. But they write may not in a way that suggests that the other party can get out of it. The context of how may is used, in fact, shows that the parties did decide that they wanted to refer. It's just that either party may start it. So the current approach of under Singapore law at least is that even if the clause uses non-mandatory language like may, that doesn't mean that the clause is ineffective. So that's to give you an example of how you can take a pro-arbitration approach. There are many other examples, such as where these old clauses maybe are incomplete. So the clause has blanks because many times in many trading cases, smaller cases, you're actually using a template, and then you fill up some parts of the dispute resolution portion, but they are blanks. And the approach of the Singapore courts today is that just because there are gaps, the way that the court construes the party's intention is still to see whether fundamentally, whether basically they are intending to go to arbitration. If they are basically intending to go to arbitration, even if there are flaws in the way they describe the center or spelling mistakes, or they get the rules slightly wrong, the courts will correct it, or the courts will find some way to make it capable of being performed. And we can go into some specific examples later on. One of the classic examples that some of you who are familiar with arbitration may have heard already is about just over 10 years ago, we had this famous case called the Insigma and Alstom case. You know, this was a, Tony is smiling. This was a case that that kind of pit the SIAC against the ICC a little bit and upset the ICC. Today, there's a lot of hype about the SIAC because it's become so successful in the last 10 years and its statistics have gone up. But 10 years ago, SIAC was just starting to improve, and most of the time it was trying to catch up with ICC. And then suddenly we came across this clause that said the parties agreed to go to arbitration, okay, no problem. But the parties agreed that the arbitration will be under the ICC rules, okay, that's fine, but administered by SIAC. And why did they put such a clause in? Because there was a period of time in the 1990s when, in the early 2000s, when some people in Asia thought it was a very clever idea to not have to pay the ICC fees, which they thought was high, and instead pay the SIAC fees. But they liked the ICC rules. So they say, okay, we apply ICC rules, but get the SIAC to administer it. So maybe you get a little bit of discount in the arbitrage. So that obviously made the ICC very upset because, you know, you feel as though your competitor is potentially able to hijack your case. But what happened was the SIAC said, we are prepared to try to make this work. We think that this clause is capable of being performed. It's not perfect. It's got a little bit of problems, but the SIAC can make it work. And then this was challenged and it went ultimately to the Court of Appeal in Singapore. And the final decision in Singapore was, this is not pathological, this is not defective. It is capable of being performed. And then the ICC got shocked because ICC thought, wow, if the Singapore courts support the SIAC with this, then what does this mean? We're going to see a flood of cases where they steal our rules. And then maybe even VIAC could have, no, okay, Vietnam, you can't, your law is different, but Hong Kong will start administering our rules and Korea will administer our rules and Singapore will administer our rules. So in 2012, that's when ICC made a rule change and said, only we can administer our own rules. But from a legal perspective in Singapore, I don't think it changes anything. Even if the ICC rule says only they can administer the rules, on the Singapore law position now is so pro-arbitration that in fact, if somebody else wants to administer it and it can technically be done, they will support it and say, okay, this is not pathological. So there's just a little story to show you how strongly towards a liberal position of pro-arbitration we are at. And I'm sure Mr. Minh will comment on how the same issue, if dealt with under Vietnamese law, could lead to a very different result. So so my final point is, if you're faced with cases involving an overseas seat like Singapore, at the end of the day, the way that you should think about your clause, as Tony rightly points out, is not so much about whether there's a more liberal seat that will save your clause. There will always be a more liberal seat elsewhere. The real question is, where is it going to be enforced? Because where it's going to be enforced, the test is also not whether there's this idea of pathology. The test is very simply what is in the New York Convention, as Tony has mentioned. And there, the relevant provisions are Article 5(1)(a), which is the one that talks about the validity of the arbitration agreement. And it talks about the validity of the arbitration agreement by reference to a number of laws. First is the law that the parties apply to it, if they've chosen it. And the second is the law of the seat of the arbitration. And then there are also the Article 5(2) grounds for non-enforcement, one of which is big in Vietnam, which is if it's contrary to the public policy of the place of enforcement. So that's important because that's usually a backdoor by which a Vietnamese court still uses a domestic Vietnamese conception of what public policy means. So it gives a Vietnamese court a way to say, I just disagree with the court of the seat. So ultimately, in short, you need to think about everything from a Vietnamese standpoint if you're based in Vietnam. So with those remarks, I will pause and hand over to Mr. Minh. Thank you.
Thank you very much, Yujin. You have described a very interesting case that I'm pretty sure that VIAC will want to give a say about how VIAC will deal with a similar situation where
I see that somebody in the audience has asked a very similar question, so we'll come to that.
Yeah, I just about to mention that it has been raised, I think, a few times in a few seminars, but I think I will leave VIAC. Ms. Linh is the counsel of VIAC. She will have a say. But firstly, let's hear from our Vietnamese lawyers' perspective, how the Vietnamese law deal with these arbitration agreements and all the stuff that we have been talking about. Mr. Minh, the floor is yours.
Thank you very much, Mr. Tony, and thank you all for having me here to share with you our experience on the Vietnamese law, and as well as the practical case I have been experienced before. So as you may hear from the sharing and presentation of Mr. Tony and Mr. Yujin Tay, this is a very basic issue in arbitration, and if you are doing well in the drafting of the arbitration agreement, you can avoid many confusion and many risks in the future when you have to conduct the arbitration to settle your dispute. So firstly, I think that under the laws of Vietnam, especially after the issuance of the resolution 01 in 2014, then the Vietnamese law on arbitration is much developed than before, and they are very similar to the concept and the approach of the Singaporean law, as Mr. Yujin Tay has just shared before. So, for example, for the Vietnamese law, the tribunal will and the court will also consider about three aspects of the arbitration agreement. The first one is whether there is an arbitration agreement or not. The second one is the arbitration agreement is invalid or not. And the third one is whether it is incapable of being performed or not. And I think that is quite similar to the Singaporean law. Especially in the resolution 01, there are guidance on these criteria, and the parties can refer to these criteria to argue for their case and to protect the validity of the arbitration agreement. The second one is when you mentioned about the optional arbitration clause, when you refer to both the arbitration and court for your dispute settlement. This one is also resolved by resolution 001 and under Article 2.4 of this resolution. And I believe that Mr. Tony also mentioned about this one in one of his case in the presentation slide. So basically, in case the party choose both arbitration or court to resolve the dispute, it will depends on which one the dispute is referred to first. So for example, in case you refer your dispute to arbitration first, then the court will have to reject your case and vice versa. And however, I think that the thing that is different between the Vietnamese and Singaporean approach is about how the court applies the laws in practice. And this mainly regard to the ground for setting aside or for not recognizing the arbitral award. So as you can see from the Vietnamese law, so there are two grounds that is most used for the party who want to request for set aside or request to not recognize an arbitral award. The first one is about the invalidity of the arbitration agreement, and the second one is the tribunal conducts the proceeding not in accordance with the parties' agreement. So for these kind of grounds, in case the arbitration agreement is well drafted from the beginning, there will be little to no room for parties to argue about the invalidity or the enforcement or conduct of arbitration agreement in practice. So I just want to share with you from my personal experience, I think that there are two ways you can draft your arbitration agreement. The first one is to make it as simple as possible, and you may refer to the modern clause of the arbitration institution, because I think that most of the rules of institution now are very well developed, and you can rely on that without having to invent, like Mr. Tony said, invent something new or invent something too complicated. And this is important. There are some kind of important factor in an arbitration agreement that you need to focus if you want to take this kind of approach, a basic one. So the first one I think is the place of arbitration. because this one will affect the law that govern your arbitration proceeding. The second one is about the language of arbitration, because this one may relate to the language of the contract or agreement, and you may have to interpret your contract when you resolve a dispute. So if the language, for example, the language of arbitration is the same language of the contract, the prevailing language of the contract, it will be much more easier for the parties to argue, and for much more easier for the tribunal to understand and resolve the dispute. And the last one, I think, is this number of arbitrators, 1 or 3 or more. And I think that these 3 factors are the 3 main important factors if you want to apply a modern clause or a basic approach of the arbitration agreement. But in case you want to use a modified one, just like Mr. Tony said in the presentation, he mentioned about the modified one that, for example, the parties also agree that any issue as to the existence, validity, or termination of this agreement will also be settled by arbitration. So just want to share with you about the history of this kind of modification. So normally the modern clause is enough for the parties. However, previously under the Civil Code 2005 of Vietnam, it did not mention about the arbitration and only refers to the court for a settlement of the civil matters, and also including the declaration of an invalid civil transaction. And this led to the argument that the arbitral tribunal does not have the power to declare a civil transaction invalid. So in order to mitigate the risk that the arbitral tribunal cannot have such kind of power, then several parties insert into the arbitration agreement an express wording that the validity of the contract is an issue that can be determined by arbitration. However, I just want to note that the risk is now further minimized due to the introduction of the Article 14.1 of the Civil Code 2015, because this article can be used as a catch-all provision, which stipulates that in case a civil right is violated or in dispute, the protection of civil rights can be done in accordance with the procedural laws at court or arbitration. So this is like a catch-all provision that in case you refer your dispute to arbitration and you request the tribunal to declare the contract invalid, it can still work under the law without the parties having to modify the model clause to reflect that. But in case, for some cases, you have to use a complicated arbitration agreement. For example, in case you want to encourage the parties to amicable settlement, or in case of multi-tier clause like the one normally used in the construction contract, then my advice is that you should make sure that it is an effective and enforceable clause. This is because when you, for example, when you use the multi-tier clause without having a clear and enforceable process, then you may have trouble when you want to refer the dispute to arbitration. So when you signing the arbitration agreement and signing the contract, normally the parties are in like in honeymoon. So they prepare to conclude a transaction, a big transaction, and then they're about to celebrate, and they usually try to work in a very good faith to agree on anything that they can reach an agreement, including the arbitration agreement. So this is the time you should try to make your arbitration agreement as clear as possible. So I think that the following should be careful and taken into consideration if you apply for the complicated agreement or you want to apply the multi-tier dispute resolution clause. The first one is you should have the timeline for each step, because and of course it's including the starting time and the deadline for the step. Because if you do not have that, then there may be a dispute in the future that whether a step in the multi-tier process has been fulfilled or not, and whether the parties have the right to refer the dispute to the next step or not. This is very regular, and I have met this many times in my practice. The second, if the dispute board or an adjudication board is involved, usually in a construction contract or construction dispute, so the process should be clear and consistent, especially between the general condition of contract and the particular condition of contract. Because normally in the construction contract, you will, especially for the large project, you will have to modify many things from the general condition, and you will have the particular condition. And in such case, please make sure that they are consistent with each other, and then there will be less chance to have dispute in the future on the inconsistency. And also, if you want to set out the criteria for the adjudication board members or the arbitrators, it should be viable and should not hinder the parties from establishing the adjudication board or the tribunal. Because I have, for example, I had a case before. The parties agreed to set out certain criteria for having arbitrators in their potential dispute in the future. And at that time, they set out the criteria which is quite high, because they think that in case of dispute that the parties cannot resolve and the adjudication board also cannot resolve, then it will need an arbitrator who is very, very profound and very, very experienced to resolve that. However, after the dispute arose and then the parties failed to settle it in an amicable way, and also failed to settle it successfully via the adjudication board, then the parties referred to arbitration, an institution. However, at that time, the institution could not find any arbitrator that met all the criteria between the parties. And then luckily in such case, the parties reached another agreement on the criteria of the arbitrator, and then the process of arbitration could go on. But in the worst case scenario, if the parties cannot reach such kind of agreement, I think that such kind of arbitration agreement cannot be performed. So the intention of the party, original intention of parties to have the dispute settled by arbitration will fail. So I think that that's all I can share from my experience from the Vietnamese law as well as from my previous practice. And I'm very willing to answer your question if you have on this issue. Thank you.
Thank you very much, Mr. Minh. I think Mr. Minh has shared very interesting knowledge and also tips, especially with the multi-tiered clause. I know that we have had a few other webinars approaching this topic, but anyway, it is important to re-emphasize the importance of these tips when you want to make sure that your arbitration agreement is enforceable and is operative. Now I will pass on to the floor to Ms. Linh, our youngest but very capable counsel of VIAC. And I hope that Ms. Linh will be able to answer the question that we discussed before between myself and Yujin Tay on what is VIAC's view on this. Of course, you don't have to answer, but if you can, it's very interesting to hear. Thank you. The floor is yours, Ms. Linh.
Yes, thank you very much for all of your views and sharings previously. I think our previous fellow speakers have already said quite enough and very insightful about our topic today. And I think what I can share with the audience today is just from my personal experience as serving as a counsel at VIAC, what I usually see as a problem arising when one party wants to initiate an arbitration with their already existed arbitration agreement. So for this purpose, I've prepared a very short presentation for so that it's easier for the audience to follow, but I would like to share here. Now, the first situation that I usually see in practice is an arbitration clause or arbitration agreement with unclear intention to arbitrate of the parties. So usually the parties use ambiguous wordings or referring to both arbitration and national courts, which leads to the situation in which it is difficult for even the parties and also for the tribunal to determine whether the party truly wants to bring their dispute to arbitration or to national courts. So I've put here 2 examples of such clause in which one they refer to both VIAC and to the Economic Court of the People's Court of Hanoi. So there are 2 options. It makes the arbitration agreement sounds optional, as Tony has just mentioned. And the second one is quite interesting. Any dispute arising out of in connection with this contract shall be resolved by arbitration at VIAC, but the judgment of the Economic Court of Hanoi shall be final and binding for the parties. So they mention arbitration, not directly the courts, but the judgment of the courts will be final. So I think generally this case, when tribunals at VIAC face these circumstances, they usually recognize and try to give effect to the parties' intention to arbitrate, and this is also supported by the law, particularly provided in Article 2, Paragraph 4 of the Resolution Number 1 in 2014, which says that if the parties agree to bring their dispute to both arbitration and national courts, then they can, one party can initiate an arbitration first. And if the courts receive a petition from the plaintiff or the claimant, but there has been an arbitration proceeding going on before the petition was filed in the court, then the courts will return the petition and dossier to the plaintiff. So this has been remedied specifically by the law. The second common situation that I have seen is an arbitration agreement by which it is unable to determine the arbitration institution, either by referring to the incorrect name of the arbitration institution or reference to the rules of such arbitration institution only. So the first scenario of incorrect name is quite straightforward. For example, instead of saying VIAC, they're saying something like Vietnam Center for International Arbitration Center. So it's quite similar, but it is not exactly the name of the center. And the second circumstance here is the parties only reference to the rules of arbitration of that institution only, without referring to that specific arbitration institution. And so this is this might be quite tricky because there are still situations where the parties choose one arbitration institution and still want to use other rules of arbitration of another arbitration institution, and therefore reference to the rules only usually does not surface. And this has been also remedied by the law and commercial arbitration by Article 43, Paragraph 5, in which it is provided that the parties has the second chance to renegotiate and reach an agreement on the exact arbitration institution that they want to refer their dispute to. And in case the other party does not respond or does not agree with the proposal of the claimant, then the claimant can right away initiate an arbitration at the institution that they of their choice. The third very common defective clause that I usually see is the tailor-made procedures, which are inoperative in practice. Usually the parties, especially in very complex and high-profile transaction, the parties wants to make their own arbitration agreements. However, if they're not sure, then the procedure that they agree in the contract might be troublesome in practice. So usually the parties agree to a specific procedure for constitution of the arbitral tribunal, which is either unclear for the number of arbitrators or providing for very overlapping or complicated time limits, or the procedure depends on the external appointing authority or cooperation of the respondent, in which case it would be very difficult to proceed with the agreed procedure. Other procedure that the parties may agree on is the procedure for service of notice of arbitration or exchange of documents, which might be also difficult in practice, especially, for example, in the case where VIAC administer the arbitration, because as you may know, in VIAC administer arbitration, we monitors and conduct all the exchange, control all the exchange of documents within the arbitral proceedings. And therefore a tailor-made procedures of service of notice and exchange of documents, which is not so incompatible with the VIAC's rules, may affect the efficiency of the proceedings. And finally, I've also received a lot of questions relating to multi-tiered dispute resolution clause, whether it is a defective or pathological clause or not. In my personal opinion, I don't think this is a defective or problematic at all. I think if the parties have a clear enough multi-tier dispute resolution with the clear step and procedure to conduct in practice, as Mr. Minh has just mentioned, then it is quite straightforward for the parties to follow their tailor-made procedure. I think the conclusion to this part is that if you are unsure about the operation of your self-made arbitration agreement in practice, then does use the provided rules, because our rules are made so that it is effective and efficient in practice. Some other, now this is the situation that has been asked by one of our audience and also mentioned by Mr. Yujin Tay, that are the arbitration agreement with incompatible agreement elements, such as arbitration at VIAC, but under UNCITRAL rules or SIAC or ICC rules. Now, I think this is, sorry, I have some technical issues. No, okay. So I think hybrid arbitral proceedings are maybe accepted and conducted by different arbitration institutions, but with very careful consideration and examination on the efficiency of the proceedings. Because, for example, the UNCITRAL rules is the rules that is designed for ad hoc arbitration and not institutional arbitration, or the difference in the administrative organization of different arbitration institutions like SIAC, ICC, or VIAC also creates some problem in the conduct of the proceedings by one institution, but with the application of other institutions' rules. For example, VIAC has the court of arbitration of VIAC, and also the committee of the court, and also the registrar. Whereas ICC has the ICC court and ICC secretariat, who has different deciding jurisdiction over their rules. However, at VIAC we don't have VIAC courts of arbitration. We only have VIAC secretariat, and therefore some deciding power and other procedure that is provided under the VIAC rules or the ICC rules might be inoperative if it is conducted by the administrative organization of VIAC. And therefore, I think it is the best for the parties to carefully consider all the factors that regulating and affecting the arbitral proceedings, to ensure that there's no conflict during the conduct of the arbitration, as well as to limit to ensure the efficiency of the arbitral proceedings. The final situation that I've already seen in very commonly in practice at VIAC is the arbitration agreement with unclear or narrow scope of dispute. So, for example, instead of saying all or any dispute arising out of this contract, the parties say something like disputes relating to this contract, including its existing validity or interpretation of the contract, shall be resolved by arbitration. Then these words like including may lead to different interpretation in practice. For example, some may argue that this the word including is for the purpose of listing the exclusive type of dispute to be resolved by arbitration. However, others may argue that including here is just listing the example of the dispute, and therefore it has the broad meaning of covering all the dispute relating to this contract. This list has, in practice at VIAC, it has led to some controversies and has led to some different decision by different tribunal. So I guess it is the best to state it in general and very clear wording that all or any dispute arising out of or in connection with this contract shall be resolved by arbitration, for example. That will then remedy this type of defects. Thank you. I think that this ends my presentation for now from the perspective of a counsel at VIAC.
Thank you, Ms. Ling. Quite interesting information. And I guess from what I heard, I'm still looking forward to the information that I want to hear. Actually, it's one of the questions was about whether or not the parties may choose the VIAC, but then apply the rules of ICC. Yeah, I know it's sensitive, but from my own sharing, I think it is not advisable for anyone, even if you like or you dislike something, to use a hybrid organization, an arbitral institution, and then put it on top of the rules of something else, which is designed for that particular institution and in that country. But if that exists, then theoretically, I think you have explained that it still can work out, right?
Yes, we. I want to share one case where the parties actually choose VIAC as the administering arbitration institution, but with the application of UNCITRAL rules. So you know that UNCITRAL rules is the rules designed for ad hoc arbitration only, and VIAC still managed to conduct arbitration initially by that rules. However, with all the instructions, very complex instruction and requirements from VIAC Secretariat in order to ensure the arbitration is conducted exactly in accordance with the UNCITRAL rules, the parties feel so confused, and they finally, in the middle of the proceedings, reach another agreement to amend their original arbitration agreement to switch from the UNCITRAL rules to VIAC's rules, and in that way, it is more efficient.
Yeah, I think that's another misunderstanding, because UNCITRAL rules is really ad hoc based. So it's not institutional. So it's really not fit on purpose. You're trying to put an apple on top of an orange tree and hope that it will fruit. I think now it's time for the questions. I have seen quite a number of questions, and we don't have much time. So let me start with the first question from Ms. Mai Lei. What is the difference in terms of validity? I think she's trying to say the validity of the arbitration agreement under the New York Convention and under the Model Law 2006. I think it's quite a basic question. Yujin, do you want to give an answer? The question is, what is the difference in terms of validity? I think I'm not so clear if she tried to say validity of the arbitration agreement under the New York Convention and the Model Law 2006.
Sorry, I'm very, very wary of simple questions because they're usually the most difficult. Well, so, Mr. Chairman, how do you frame the question again? What is the difference between the validity of an arbitration agreement and?
Under the New York Convention and under the Model Law.
The concept of validity is the same. So we're trying to figure out whether the arbitration agreement can be made in terms of its formal requirements as regards the applicable law. But the instruments that we're checking are different. One is the model law, if it's a model law country. The other one is the New York Convention. But the New York Convention would generally have to be reduced into a local law anyway. So it would be the local law that applies the New York Convention. And I think that the answer is to determine validity, and that's why this topic is so interesting. You probably have to look at more than one place. It's not, the answer is not necessarily neatly only in one law, like your arbitration ordinance. Because, for example, the question of arbitrability, which is a very difficult question under Vietnamese law, and has a lot of, you can have a lot of debate on it, depending on which Vietnamese law expert from which field and which topic you approach. You know, there's a lot of lack of clarity. And again, it depends on whether your courts are conservative or liberal. A conservative approach is to say, unless the law tells you it's arbitrable, you should assume maybe it's not arbitrable, because the law presumes that more cases should go to court. But if the legal system is liberal, then it will presume that just because nobody says it's arbitrable doesn't mean it's not arbitrable. And only if the law says it's not arbitrable, then it's not arbitrable. So Vietnam will have to find its position, you know, where it wants to plant this. And all the lawyers who are attending this webinar, especially if you're litigators appearing before the Vietnamese courts, you all have a part to play in this. You are a bit like the audience in a song competition, you know. If you want the Vietnamese courts to be more liberal, then don't make arguments that push them towards a very illiberal answer. Although, of course, all of you want to win the case for your client.
Yeah, all right, thank you. I guess the question is more in relation to the formality requirement under the New York Convention and the model law. It sounds to me that the model law is more liberal in terms of the requirements, especially the option 2. It does not require any form of the arbitration agreement. But at the end of the day, we all know that we have to bring it to enforcement, and you have to go through the New York Convention test.
The problem is that the New York Convention has all these back doors, you see, that allow you to either bring in arbitrability, which opens the door to many other laws and considerations. Yes. And then you have public policy, which allows the judge to arguably decide whatever they feel like. And you have the formalities part, which is about the validity of the arbitration agreement. That is Article 5.1a. So once you start to look into the enforcement side, then you have more excuses, more problems. And traditionally in Vietnam, those are the grounds that all the clever lawyers use to resist enforcement. The arbitration ordinance itself is easier, but I think it's the back door that worries me.
Thank you, Eugene. The next question is from Mr. Thái Thanh Tung. He asked, he said that I currently work in an import and export of PE plastic bits, and most of our contracts with foreign clients are countersigned. The exchange of contracts normally are done at the time of the last payment. So we have issues with some outstanding amounts from some clients due to COVID-19. Since last year, I was advised by my friends who are experienced in dealing with disputes that our dispute clause in the contract mostly have signature of one side only. My company, they might be considered invalid. So only we sign the contract. The other side did not sign it. May I have your opinions on my case? I think this is not clear whether which law is governing the arbitration agreement, but I assume that it is Vietnamese law. Then I will turn this question to Mr. Minh. Do you want to share your view on this?
Thank you for the question. I think that in order to answer your questions in a comprehensive way, it will not be possible with the current available information. However, I think that there are some factor that you may consider to explore in your dispute. The first one, I understand that basically this is a question on whether a countersign agreement with only your signature, without you having received the signature or the signed version from the counterparties, will be enough for you to trigger the dispute resolution or not. So I think that you should look into the first one, whether the communication between the parties can be considered like an acceptance of the contract or not. The second one is you may look at the trade experience between the parties to see whether this is a trade custom between the parties, and without having to receive the countersigned version from the other parties. And if it can constitute an acceptance from the other parties, either by way of communication or by way of trade custom between you and your counterparties, I think that it will constitute a valid dispute resolution in this case.
Thank you, Mr. Minh. I hope that the answer clarified and the situation and satisfactory to you, Mr. Tung. Yeah, I also, as a lawyer, I observed the same thing. We will try our best to establish some communication to confirm the contract, to affirm the contract. The next question is from Ms. Doan Ngoc. I understand that when an arbitration clause is defective, it requires interpretation by the parties and the arbitration tribunal. Is there any principle in interpretation being applied in these situations? Are they the same with principles of interpreting civil transactions? Thank you. Yeah, again, we need to split which law is governing the arbitration agreement. But this time, I would like to hear from an international perspective, maybe from Singapore law perspective. How do you interpret the arbitration clause, Eugene, from Singapore law perspective?
So the short answer is we treat, as many of you may know, we treat the arbitration clause as an agreement within an agreement. So the arbitration clause is often inside a contract, and we treat that as a contract within a contract. And the way that we interpret the arbitration clause is the same way that we interpret any other contract, which is to try and find out what is the intention of the parties. And I think almost every legal system in the world, whether it's a common law or civil law system, is essentially trying to do the same thing. And to the question that was asked earlier, is it signed, not signed? The problem that you have, well, in theory, you don't need to have signature because you just have to have agreement in writing. The issue you have is, has there been an agreement if the agreement requires you to sign? So, you know, so it's circular. But even trying to ascertain that to answer the lady's question, this is applying rules of contract interpretation, which is under your civil law.
Yeah, I guess the answer will be the same under Vietnamese law, unless Minh or Linh would like to put something else on it. Let me move on to the next question. Mr. Nguyen Nam, he asked, I'm working in a software company and once participated in an arbitration case. In the first hearing, the opposite party argued that our claim of our copyright over the software we designed upon their orders could not be resolved by arbitration, but the court, and they won on that point. To avoid that situation, can we put in the arbitration agreement that the arbitration shall resolve all types of arising disputes without exception? And from your experience, if there is other way to avoid such situation, please share with me. This is, of course, from a Vietnamese law perspective. So maybe Minh, do you want to give it a try?
Okay, so for this question, I'm not sure whether this is a contract under this is a dispute under the Vietnamese law or not, and I'm not sure what is the ground that the tribunal based on to decide that your counterparty won on this point. But normally, just want to share with you. Normally, in the contract with regard to the copyright issue, in the contract there is usually a provision stipulating on the copyright of the product. When you provide the product to your customer. So I think the first advice here is that you should include such kind of provision in your contract if it's not already there, because in the future you can, based on the provision of the contract, to argue that this copyright claim is arising from your contract. So the second advice here is that, like the speaker has shared before, if you want all of your dispute arising from the contract to be settled and resolved by arbitration, you should make it clear in your arbitration agreement, and I think that's the good thing. So I think that can answer your questions.
Yeah, thank you, Minh. Eugene, you want to share from Singapore law perspective?
Or maybe from any law. I think the any law perspective, just to share, I suspect the way that it was resolved was the tribunal decided that the question was not arbitrable. It's quite common in IP cases that, especially when it comes to patents, although yours is about copyright, that many legal systems treat those questions as pure questions for the intellectual property courts or the general courts of the country to resolve. So unless the law, the legal system allows those IP disputes to be arbitrable by law, generally it's treated as not arbitrable because it's a kind of property right that affects third parties. Just to share with you that in Singapore, we recently legislated to allow all IP disputes, including patent disputes, copyright disputes, to be arbitrable. And the fact that we did that shows that there was, there's quite a lot of controversy as to whether it would be. But license disputes, which are contractual disputes, those definitely can go to arbitration. So something to bear in mind. I think it's an arbitrability question.
Yeah, I think that that really complete the answer. I just want to share with you two cases in the court of Vietnam recently. in relation to the arbitrability of the arbitration clause. I think the test for Vietnam is quite simple. It's in Article 2 of the LCA, of the Law of Commercial Arbitration. As long as a party to the disputes has commercial activities, it is arbitrable. And only in the cases where we have specific provision in law that establish the sole jurisdiction of the court, then arbitration will not be able to proceed. And that has been clarified in a case in 2018. The number of the case is 755. You can see it in on the website of the Supreme Court. That case was dated 12 June 2018. It was in relation to a non-disclosure agreement as a part of the employment relationship. Normally, we believe that employment is not arbitrable, but in that case, the tribunal, the court accepted that it is arbitrable. And in another case, which is quite interesting, it is a non-commercial civil transaction. In 2014, there's a case where the dispute was on rental of land and the house on the land. The court rejected the respondent's argument that this is something related to land, so it is unarbitrable. The court said that the law do not specify that requirement. The law is very simple, and there's nowhere in the land and in the law of the land telling you that the court is the sole jurisdiction, the sole forum to deal with that dispute. So the dispute was confirmed to be arbitrable. So in that respect, I think the situation with the software or the intellectual property rights must be a very specific area that the law provided that it's not arbitrable. And I know that English law also provides the same approach. The infringement of the IP rights must be dealt with in the court. It's not arbitrable. So it's the same, I think, in other common law system. The next question, I hope that it is satisfactory. The next question is from Ms. Ling. As I know, the arbitration agreement must be agreed to be binding, not optional. I joined a conference by VIAC, and one of the VIAC representatives said in that conference that enterprises who are not yet so familiar with arbitration might put a clause of court and VIAC in the contract. And when the dispute arises, the claimant could choose VIAC or the court. Is such type of clause practically valid at VIAC? As I understand, it is an optional arbitration agreement. And I think Minh would like to answer this question. I think we covered this, but just to be clear, Minh, can you clarify the answer for Minh?
Yes, previously I would like to answer this question because it's relating to the optional arbitration agreement, and it relating to the similarity between the Vietnamese law and Singaporean law. So as I previously mentioned in my presentation, this kind of optional arbitration is already settled and resolved by the Resolution 01 in 2014, and you can look at Article 2.4 of this resolution to find the specific answer. However, I think that Ms. Ling can share with you the opinion from the perspective of VIAC on whether this optional dispute resolution clause is advisable for enterprise who are not yet to be familiar with arbitration or not.
Yes, thank you, Mr. Minh, for yielding the floor back to me. I guess you are right in referring to the exact provision of the law in the Resolution number 1, 2014, in which it is the law specifically give effect to the parties' intention to arbitrate, even if it is unclear whether the parties truly want to go to arbitration or go to national court. However, even though this type of mistake in the dispute resolution clause is remedied by this provision and it is enforceable, such type of arbitration clause is enforceable in practice at VIAC. I don't think it is advisable for the parties to follow this trend in order to. I know that I've heard some opinion from the enterprises who comes to VIAC for advice that they don't want anything that is too binding on them, whether it is just arbitration or just the national court. So they open to two options. But I want to note that please bear in mind that if there are two options open to you, then there are two options open to your partner as well. And it is still possible that a court proceeding against you has been initiated by your partner before any arbitral proceedings is brought at VIAC by you. So you never know when and where you're going to be sued. So in order to increase the certainty of the potential proceedings that might arise from any difference or dispute between the parties, then it is advised that it is recommended that the parties should avoid using this type of clause. If you are unfamiliar with arbitration, if you are a newbie, then it's okay, because don't worry, because the VIAC Secretariat is always here to support in each and every stage of the proceedings to keep you fully guided during the arbitral proceedings. Thank you.
Thank you, Ms. Linh. I think Eugene want to drop in. Eugene.
I just wanted to say this is a very interesting topic because, and I think Ms. Linh gives good advice. But Ms. Ling's advice is what's advisable. Sometimes clients don't listen to advice. And I've definitely also detected very strong interest in these optionality clauses, option clauses, and it was something we didn't go into, asymmetrical clauses, etc. But option clauses, the option, both sides is important, not one side, but both sides have a choice of choosing VIAC or Vietnamese courts when the dispute arises. My personal view and the current position under Singapore law is there's nothing wrong with it. It's mutual. Each side has the ability to choose. It's clear, it's something that you can perform, and it's what the parties have agreed. So why can't we perform it? So the answer, and I think as I understand it under Vietnamese law, correct me if I'm wrong, I think it's also enforceable. It's just that Ms. Ling is saying it's not advisable because it could go against you. But you know, we talked about earlier, the type of clause that Tony referred to, the type of clause that is designed to encourage people not to fight, because whoever goes first will get a disadvantageous seat. This kind of clause, this kind of option clause, where either you can go to VIAC or to courts and each side can choose, achieves the opposite result. It encourages you to fight because it encourages both sides when there's a dispute to rush to be the first one to choose. So I think what I would add to Ms. Ling's point is not so much whether an optional clause is valid. I assume it's valid. The real question is, do you want both sides to rush to fight? Because what it will mean is that you will be rushing. When you have a dispute, whoever wants to make the choice will rush. But I do think it's part of an option clause is that once one side has made the choice, then the others, if they chose VIAC, then the Vietnamese courts should uphold the arbitration agreement and refuse to take jurisdiction and vice versa. I'll be interested to watch the space. I think in Vietnam, you should have quite a lot of these happening soon. But Singapore is very clear. If there's an option, it's valid. And the other thing I would add, I think Ms. Ling, you touched on it, about the internally inconsistent clause. You know, you have the clause that says, one sentence you say go to VIAC, then the next sentence you say the Vietnamese economic court has
yes, the judgment of the court.
We have a very recent decision, actually, just of last year, a Court of Appeal decision in Singapore last year that dealt with this very similar fact situation and found that it is not it's not problematic, that you can enforce it, and unsurprisingly, they enforced the arbitration part of the clause because they said the parties made a mistake, but it's very clear they made a mistake in the second part. They didn't make a mistake in the first part, so it goes to arbitration.
Yeah. What if actually the party made a mistake in the first part and not the second part?
That's why I say it depends on your
pro-arbitration approach. Yeah, how we interpret it. Yeah, I think in my slide a very similar situation arises, but a little bit different, where it is unilateral. So only one party has the option either to choose court or arbitration. The other side has been fixed to only one method of resolution. And that raised a lot of issues in terms of fair and good faith negotiation and all that type of things. So I think in the first place, it's not advisable to have things complicated, but at least from our perspective as advising transaction lawyers, I have to issue a lot of legal opinion on this type of lender-borrower arbitration clause, and that is always the lenders having the advantage over the borrower, and that is not unusual that they try to enforce that type of clause. And a general remark or comment on that is that from a Vietnamese law perspective, there's always a risk for the lenders trying to enforce this type of clause, is that the right to go to court is almost a natural right of a party. So it's very difficult for you to avoid that if unless you have a very effective and strong arbitration clause. So that may sometimes go back against you as a lender trying to have more flexibility than your counterparty, which is the borrower.
I think the free advice I'll give, I've been doing this for about 20 years when these asymmetric clauses first came about, is that a lot of the guides on the internet, and I don't tell you, I think it is a lot safer if your base is arbitration and both sides have agreed, and then the lender has a choice to elect for court. Because in that situation, it should be a lot more difficult for the unhappy borrower or the respondent to challenge arbitration. And as for jurisdiction, it's just purely up, for courts, it's purely up to the courts to decide whether they have jurisdiction. Many of the cases that we actually see going to judgments all over the place are cases where one of the parties, the bank often or the lender, has the option to choose arbitration. And then you say, it's not balanced because you don't have mutuality. The case that was on your slide, Tony, the Dynajet case in Singapore, was a case where it was the option to go to arbitration. It was exercised. And there the Singapore said, not a problem. You can, as long as it is not null and void, not inoperative, it is capable of being performed, then it's fine. And
now we see the difference. We see the difference between Vietnamese law and Singapore law.
Correct. But on this area of asymmetry, the difference is really between common law jurisdictions and civil law jurisdictions. Even France, which is generally pro-arbitration, is the one that has issues with it. So France, Russia, Vietnam, most of the civil law countries have a problem. But it's not stopping the banks from doing it. The banks are still putting it all over the place. Why? Because the problem they have is with these civil law countries. In Asia, it's Indonesia, Vietnam, China. These are the countries that they're concerned about, right?
Yeah. Thank you for the sharing. Very interesting topic. The next question, I'm trying to get up to the speed. We have so many questions. Ms. Nguyen Trung Nam wants to ask, I hope to hear more sharing on how to remedy a defective arbitration clause. In my experience, not many consulting lawyers care about arbitration clause when they draft the contract. And so when the disputes arise, the case usually goes to litigation lawyers, people like me. So I'm more interested in the ways to fix the problems. Thank you, VIAC. So I think this question goes to VIAC, but just a quick tip that I already made and some other speakers already made. The easiest way to fix it is to use a model clause, because the model clause has been applied and survived and stand through so many cases. So if you want to have it fixed in the quickest way, just use the model clause. You don't have to worry about other things. But of course, I will pass it on to Ling because the question is actually to VIAC. Ling, you want to share some tips?
Yes, I think this question is very broad, which has been addressed from time to time by all of our speakers previously. I guess this really depends on what kind of defective clause you're facing, because there are many kinds of defects that has been mentioned, whether it is in unclear intention to arbitrate, or whether it is incorrect with the incorrect reference to the exact name of the arbitration institution, or whether it is narrow scope of dispute. So there are some defects that may be remedied by the law. For example, like Article 43.5 of the Law on Commercial Arbitration, or by the resolution number 1, as mentioned previously by Mr. Minh and by myself. So those are the sources that you can take a look at if you're facing a defective clause.
Yeah, I guess we cannot answer more specifically because the question is quite broad, as you rightly say, Ms. Ling. Ms. Bạch Bảo Duy Anh asked the question of having the rules of VIAC, and she said that the arbitration clause referred to disputes to VIAC, but use the rules of SAC or ICC. I think this has been addressed, and basically the answer is it is workable, but in a very difficult way, right? So I will pass on to the next question, Ms. J. Chu. 2 questions. Question 1, if the arbitration agreement does not specify the seat of arbitration, practically, which would the tribunal generally choose to be the seat of arbitration? I think I addressed partly this question in my own slides, where I said that usually the tribunal will look at the most closest connection test. But maybe, Yujin, you want to add any point to that?
Are you referring me to the proper law of the arbitration agreement question?
That's the question. Yeah, it is. No, this is a dispute over the conflicts of law.
Sorry, this is about the one where if the clause refers to the ICC Shanghai office, and then the other clause refers to...
The arbitration clause does not specify the seat of arbitration. Practically, which would the tribunal generally choose to be the seat of arbitration?
Oh, if the clause doesn't specify the seat, but the... well, if the clause doesn't specify the seat, then the arbitral tribunal, and in many international law cases, the treaty may not specify the seat, and it lets the parties address the tribunal on it, such as disputes between 2 governments under a treaty. Sometimes the seat is not specified. Then typically, if the parties can't agree, then they will have to make submissions to the tribunal, and the tribunal will apply their discretion. There isn't a test. They'll just apply their discretion as to what they think is fair, usually end up with something that is neutral, but with some kind of connection to both parties.
Yeah. Thank you, Yujin. The second question is, what are the advantages for a foreign party to opt for the seat of arbitration in Vietnam, and vice versa, for a Vietnamese party to opt for a foreign seat? I think this question can firstly go to Minh, as you frequently advise clients on whether to choose the Vietnamese seat or the foreign seat.
Okay, so I think that there will be no concrete answer for this, but I just want to share with you some kind of factor that you may consider when you want to choose a seat for arbitration. So the first one is about the familiarity, whether you are familiar with the law of the state or not, because it will affect a lot on your proceeding. Second one is you may consider about the enforceability of the award. And the last one, I think, is about the cost, whether you want to, for example, in case you want to settle your dispute and have the seat of arbitration in Vietnam, the cost will normally be less expensive than having a seat in foreign country.
Minh, can you elaborate the last point that you make? The cost if you choose the seat in Vietnam would be less expensive than, for example, one in Singapore. Why is that?
So in my opinion, when you choose the seat of arbitration in Vietnam, normally you will engage Vietnamese lawyer, Vietnamese counsel to support you, because they are the one who are familiar with the law of Vietnam on the proceeding. So that's the first thing that may help you to have a less expensive arbitration cost. And second thing, it may not always, but it may depends on the or linked to the venue arbitration. So for a Vietnamese party, they may not have to go to a foreign country to attend the hearing if the seat of arbitration in Vietnam. I just want to clarify that the seat arbitration and the venue of the hearing is not similar. It's not the same. But in case the seat arbitration is in Vietnam, it can be determined by the tribunal that the hearing will also be held or convened in Vietnam. And I think that can help to reduce the cost of arbitration to your company.
Yujin, you want to share some views? I think I will have some comments too, but I want to reserve it after I hear something from you as a Singaporean arbitrator and lawyer. What do you think?
Maybe I try to take the words out of your mouth, Tony, which is I don't see a difference between whether the seat is in Vietnam or outside of Vietnam from a cost perspective. Even if the seat was Singapore, you could go to Tony's very capable firm. I'm not suggesting for a moment that Tony is cheaper than foreign lawyers. Tony is probably more expensive. Just a joke. You can use Vietnamese lawyers for arbitration seated outside Vietnam or in Vietnam. And similarly, it really depends on the client. Foreign parties will use a foreign lawyer even with a seat in Vietnam. So to me, it's not so much the cost issue, although, I mean, actually, I don't disagree. I mean, in general, there might be a cost difference, but in practice, that's not what decides. In many cases where the client is a foreign party and they are asking, oh, why should I choose Vietnam seat? The short answer is a lot of the times they don't have a choice. If they want to do the business, they may not have a choice. They may have to take Vietnam seat because maybe the contract they are bidding for, let's say it's an infrastructure project, is take it or leave it. It's VIAC seat Vietnam. If you want to do the business, you have to accept it. Otherwise, you can't. If they do have a choice, usually their concern, what they're bargaining over is it going to be more advantageous to us because the counterparty is Vietnamese party and all their assets are in Vietnam. So even if we were to have a dispute and we wanted to fight it, get an arbitration award, it's still going to be enforced in Vietnam. So which one is faster? Then of course, this is a VIAC event. The VIAC answer and the Vietnamese answer is of course that if you choose seat Vietnam, it'll be faster. And there are less cases, less successful setting aside cases. So there are many foreign parties who are beginning to hear this, they understand this, and they are actively choosing VIAC, they're actively choosing Vietnam seat, not because they think it's going to be bad for them. Many of the times, if they choose the foreign seat, it's because they are worried that this contract is large, the case is large, and that there is a concern as to whether maybe one of the drawbacks in the Vietnam seat is that if there's a challenge to the award, then the challenge is only one level to one court with no right of appeal. So the danger is they feel that they've invested a lot of money in the arbitration, but maybe the losing party could find it quite easy to challenge. So that's one of the types of considerations that come about. There's no easy answer.
Thank you, Yujin. Yeah, I guess this is a huge open topic, and the seat of arbitration is quite everything in the proceeding. So I guess it is a relationship between the courts and the arbitration proceeding. If you want to have a law that back up all the procedure in the most pro-arbitration way, you may try to choose the seat of arbitration where it is most convenient, and it will give the proceeding the best result, the most fair and equitable and fast and effective result for the dispute resolution. But now the Vietnamese seat is improving. Yeah, of course, in terms of cost, as Yujin rightly pointed out, it doesn't make any difference. But the environment will be different. The lawyers are different. We are in Vietnam, we are Vietnamese lawyers. We are operating within the VIAC most of the time. In Singapore, a lot of law firms in Singapore operate in the SIAC environment. So there might be like convenience for the parties to choose the lawyers and representations, and that will affect the cost. But the most important thing is really on how fast you can touch the asset of the other side. And in that perspective, maybe it's a very good point for a seat of arbitration in Vietnam if you want to impose some preliminary measures. These measures cannot be done if you choose the seat outside Vietnam. If you have the assets of the other side in Vietnam, you want to enforce it, or you want to secure some assets within Vietnam. So these type of things, I think, will be advised by the arbitration lawyers to their clients. But there are so many considerations, and there might be different answers. So it is impossible to confirm a yes or no for either Singapore, Hong Kong, or Vietnam, or any other neutral seat. I think the next question is from Mr. Mike Kuang Tang. He has a question on the existence of a typo in an arbitration clause, and it's a fraction to the arbitration process as well as later stage. In particular, the arbitration clause provides that any disputes will be settled by a tribunal constituted under SIAC rules. Each party nominates one arbitrator. The two nominated arbitrators choose the third one. If the two arbitrators cannot reach a mutual agreement on the third arbitrator, VIAC president will appoint the third arbitrator. So not SIAC, but VIAC president will appoint the third arbitrator. If the parties cannot make a confirmation on the typo in arbitration process, should the arbitration clause be inviolable? So basically he asks what will happen to this arbitration clause. I think it should come to Yujin first, because it shows the SIAC rules, but then it provides that VIAC president will appoint the presiding arbitrator.
Well, for all the reasons I mentioned, if that was the clause that went before SIAC or SIAC, they will apply the clause and they will invite the VIAC. I don't think you call him president, you call him chairman, to be the appointing authority. So they will try to enforce the parties' agreement, unless there is no such person. Well, as I mentioned, even if there is such a person, there's no such person as a VIAC president, they'll find an equivalent. And often, in the same way as Ms. Ling at VIAC does, right? You know, what VIAC does is it tries to help the parties, they give advice, try and help the parties to make sure that their agreement is enforceable. So SEAC will do the same thing. You just speak to the parties and say, hey, there's this part of your provision that is a bit strange because there's no such officer, VIAC president. Do you agree that this should be treated as VIAC chairman? Then if they come back and they say yes, then they will, SEAC will approach it that way. So all the institutions, VIAC included these days, they're very user focused, they're very client focused because they're trying to help whenever the clause is not clear, such as where the clause doesn't specify what is the language of the arbitration. Then what the institution does is it tries to help the parties to make a decision that is the most efficient and cost effective for the parties, and the least complex, so that there's less room for mistakes.
Yeah.
So typos.
I think the answer is
typos can be fixed.
Maybe one party will try to convince the tribunal that it is a typo, and the other party will try to enforce what it is provided in the contract. But the very basic interpretation in any contract law of any country is that you need to look at the wording of that particular contract first. So it is the black letter rule. And if it is a VIAC president, then you should go to VIAC and invite Mr. Huỳnh to join SIAC and appoint and play the role of the appointing authority. I think we have like 6 or 7 more questions, but the time is really up now. I will have to pass the floor back to the organizers. Thank you, Eugene. Thank you, Linh and Minh, for very interesting topics and very good answers and beautiful comments. Ms. Hằng, the floor is back to you.
Yes, thank you. So over 2 hours has passed, and I think it's just a wing of eyes, I believe so. Over 2 hours have passed, and a lot of insights and practical notes have been shared by our experts, the audience. And please be informed that we have, sir, about 220 guests in this webinar. And even until this time, we still have around 100 guests with us now. So it is really a huge encouragement for us, the organizer of the webinar. So we have received 14 questions from the audiences, and most of them are responded by the expert in details. So I do believe that we have had a very great afternoon with arbitration. So now this is the last webinar of the arbitration series in 2021. I'd like to do some kind of sum up and statistic of the series. And I'd like to do so in Vietnamese as we are now live streaming on Facebook and YouTube channel of VIAC. And the English subtitle is provided in the chat box for the English speakers or viewers for convenience. Okay. Vâng, thưa quý vị ạ, như vậy là buổi hội thảo ngày hôm nay đã khép lại chuỗi hội thảo trực tuyến về trọng tài thương mại năm 2021 của Trung tâm Trọng tài Quốc tế Việt Nam. Tiếp nối thành công của chuỗi sự kiện trực tuyến năm 2020, thì trong gần một tháng rưỡi vừa qua, VIAC đã tổ chức 7 sự kiện với sự đồng hành của 21 diễn giả đến từ các chuyên gia trong nước và đến từ các cái nền tài phán nước ngoài với chuyên môn dày dặn và nhiều kinh nghiệm trong thực tiễn hành nghề, đặc biệt là trong hành nghề về giải quyết tranh chấp bằng trọng tài cũng như là giải quyết tranh chấp bằng các cái phương thức khác cũng như là tố tụng tòa án. Tất cả các sự kiện trong chuỗi hội thảo trực tuyến thì đều được tiến hành trực tuyến cùng lúc trên 3 nền tảng của VIAC, bao gồm nền tảng Zoom, trang fanpage Facebook và trên kênh chính thức trên nền tảng YouTube của VIAC, với mong muốn là mang đến sự thuận tiện cho người tham dự. Chúng tôi thực sự rất là cảm kích trước sự quan tâm và dành thời gian của quý vị đã tham gia cái chuỗi sự kiện của chúng tôi. Tính tới thời điểm hiện tại thì VIAC đã đón 4.000 lượt người tham dự trực tuyến cho tất cả các sự kiện, với hơn 40.000 lượt xem phát lại các cái chuỗi sự kiện đã ghi lại ở trên các trang trực tuyến của chúng tôi, và các sự kiện thì cũng đã tiếp cận tới 165 người dùng trên các kênh mạng xã hội của VIAC. Thưa quý vị, thì phương thức giải quyết tranh chấp thay thế và trọng tâm là phương thức trọng tài thương mại trong khoảng 5 đến 7 năm trở lại đây đã được cộng đồng doanh nghiệp Việt Nam, cộng đồng luật sư tại Việt Nam đón nhận nhiệt tình hơn. Thực tế này thì đã được nhận định ở các báo cáo khảo sát khách quan trên quy mô cả nước như báo cáo đánh giá năng lực cạnh tranh cấp tỉnh VCI trong các năm qua. Đồng thời thì cũng đã phản ánh vào số vụ tranh chấp tại VIAC với liên tục duy trì tốc độ tăng trưởng trong những năm từ 2013 cho tới nay. Tuy vậy thì để hình thành một cộng đồng doanh nghiệp tin tưởng sử dụng hiệu quả phương thức trọng tài thương mại cũng như các phương thức ADR khác, thì chúng tôi nhận định rằng vẫn còn rất nhiều các công việc cần phải làm, và quan trọng nhất là cần nhiều hơn sự quan tâm, tìm hiểu, nghiên cứu để người dùng trọng tài, luật sư tranh tụng trọng tài tại Việt Nam có thể nâng cao hiểu biết và kỹ năng để sử dụng cái phương thức ưu việt này. Chính vì vậy, Trung tâm Trọng tài Quốc tế Việt Nam với tư cách là tổ chức trọng tài dẫn đầu tại Việt Nam, dù với nguồn lực còn hạn chế của mình, vẫn luôn là nỗ lực dành thời gian và tâm huyết trong các hoạt động hướng đến cộng đồng nhằm mở ra diễn đàn trao đổi cởi mở, kết nối kiến thức và kinh nghiệm về giải quyết tranh chấp, giúp cho cộng đồng quan tâm có thể tiếp cận các cái thông tin về giải quyết tranh chấp, lựa chọn một cách chất lượng, nhanh chóng và thuận tiện. Đồng thời thì cũng hướng đến việc là tiếp tục nâng cao hơn nữa chất lượng hoạt động giải quyết tranh chấp tại chính VIAC nói riêng và tại Việt Nam nói chung. Trong thời gian tới thì VIAC sẽ tiếp tục triển khai các chuỗi hội thảo chuyên sâu về ADR định kỳ hàng năm. Từ kinh nghiệm và những thành công nhất định trong chuỗi hoạt động của chúng tôi đã tổ chức trong năm 2020 và 2021. Lời hứa của chúng tôi với cộng đồng là chúng tôi sẽ dành nhiều thời gian và nỗ lực hơn nữa để đầu tư vào cả nội dung cũng như là cách thức triển khai để có thể mang đến nhiều các cái hoạt động chất lượng và có ý nghĩa thiết thực cho cộng đồng doanh nghiệp cũng như là các cộng đồng luật sư, các luật sư hành nghề trọng tài tại Việt Nam. Chúng tôi rất là mong sẽ tiếp tục nhận được sự ủng hộ nhiệt tình của các chuyên gia, các trọng tài viên, các luật sư và đông đảo cộng đồng doanh nghiệp ở Việt Nam. Cuối cùng thì trong thời gian cả nước Việt Nam và thế giới vẫn đang chiến đấu chống lại đại dịch Covid-19, xin chúc chúng ta sức khỏe, tinh thần vững vàng. Xin gửi lời chào và hẹn gặp lại. Xin phép là kính mời tất cả các diễn giả sẽ cùng vẫy tay và sẽ chào khán giả. So I'd like to have your way to say goodbye to all the audience. So thank you so much and goodbye.